Mr. Clerk, will you call the next case, please?
Yes, Your Honor. Chris Missel, the Angela Larkins.
I'd like to reserve 5 minutes for time. This is a case in which there was a motion to dismiss that was granted with respect to a case in Chancery Court. It's somewhat fact-intensive. I'm not going to tell you all the facts. I'm going to give you sort of a prelim of facts. But first thing I would suggest is this is de novo review, as you're well aware, in connection with this. And specifically, this involves a man named Chris Missel, who is the plaintiff, has a son named Lawrence, and has a daughter-in-law named Ashley. And Ashley was represented by Angela Larkins in connection with the divorce proceeding. At some point in time, prior to this divorce proceeding, there were approximately 3 to 4 years prior to this divorce proceeding, Mr. Missel and his wife moved to Chattanooga to buy a house and be closer to their son and daughter-in-law and more importantly, their grandchildren. And so he was unavailable to be at the closing due to a situation that he got involved in with the death of his father. And Miss Ashley Missel says that she was a commercial realtor, and so she was assisting in connection with the closing. For whatever reason, I don't know what the court's all aware, it's not really in the record, but typically speaking, a lot of times when you go to a closing, someone that buys something doesn't really receive the warranty deed. It is actually returned to the title company, and generally the title company is kind enough to mail it to you because they have to have some place to mail it, and generally it's the preparer with respect to it. Needless to say, at some point in time, there was a divorce filed between Ashley and Lawrence. Subsequent to that divorce, Mr. Missel was doing estate planning. He ran across the tax assessor in Hamilton County, and he saw that the name on his deed was himself, comma, et al. And he was a little unclear about that. But at the end of the day, he figured out, for whatever reason, the names on the deed were not he and his wife, or he alone. They were he, his son Lawrence, and his daughter-in-law, Ashley. The record will show, complaint alleges, we have all these allegations in a complaint that Ashley did not know, according to her, that she owned any property in connection when she was filing an answer to an interrogatory in her divorce proceeding. Lawrence didn't own any property. The persons who signed the promissory note for the purchase of that property were Chris Missel and his wife. And they signed the deed of trust. How it happened, we don't know yet, but we hopefully will find out at some point in time. So at some point in time, we filed a complaint, and after filing the initial complaint, there was interaction between Ashley and her father-in-law, and she told him she would sign a deed. That's an allegation that's also in the complaint. And when it came time to get the deed signed, she said, well, she needed to talk to her lawyer. And lo and behold, there was no signing of the deed to correct the scrivener's error or whatever error was made. And so what did occur, I I'm specifically referring to page 153 of the record on paragraph 24 of the complaint. This states in pertinent part, on July 24th, 2024, Angela Larkins, despite Ashley Missel's sworn statements, sent a letter to Lawrence Missel's attorney, Lisa Connor, stating that, quote, Chris Missel has approached Ashley about signing a quitclaim deed to give him the house back. I highly doubt that he's asking Lawrence to do the same, but nonetheless, I've advised Ashley that to transfer this property, a significant marital asset, would be a violation of the temporary injunction unless, of course, we have full agreement on the rest of the divorce issues. Since there are only 3 people on the deed, Ashley's interest in this property could easily be valued at $125,000. Now, this is an amended complaint that was filed because there was no agreement about the deed being corrected. So that's part of the amended complaint. That is the allegation is to be construed as true. Similarly, on paragraph 66 of the complaint, it states, Angela Larkins' motive or means she employed were improper. Among other improper motives and means, she misrepresented the law regarding marital property to threaten a violation of the temporary injunction. She interfered to deprive plaintiff of his property to enhance her client's bargaining power, and she misrepresented the amount of ownership that Ashley Missel was entitled to after Ashley Missel swore she did not own any interest in the property. Now, this motion to dismiss was granted because of the attorney-client privilege. In connection with the application of that attorney-client privilege, you cannot have bad faith or wrongful means in doing something. As the court knows, if you take those allegations as true, for the purposes of a motion to dismiss, that didn't happen. What did happen, and we point out in our brief, I think it's around page 29 of the original brief, the judge focused on that statement of Ms. Larkins that was quoted in that paragraph 24. And he analyzed the actual text of that message as opposed to looking at any of and all of the other allegations in the complaint. And there was essentially 2 errors. He restricted his analysis to Ms. Larkins' quote warning to Ms. Connor rather than considering all the allegations in the complaint. And second of all, he went outside the allegations of the complaint and considered, quote, what court said is, I assess that Ashley seems to acknowledge a lack of awareness of her name on the deed. That's him interpreting these statements that are in the complaint. But the allegations in the complaint state, in a large part, Ashley knew. He's ignoring that. It's not a lack of awareness. She knew.
Am I correct in remembering that, at least in the divorce proceeding, that there was a deposition of Ashley wherein she acknowledged that she didn't know anything about her name on the deed, and didn't she also in that divorce specifically say she didn't own property? And if that's true, is that evidence in the record in this case?
Yes.
Okay.
It's in the complaint. It's in the amended complaint.
Right.
In my fairness, I misspoke. It's in the first amended complaint. Again, there are lots of facts, and I didn't mention all those, but I did mean to mention, I thought I mentioned the one at least with regard to she swore under oath that she did not own any real property. And so we also claim that she knew that this should have been in Chris Missel's name too. There's no question about that. We allege that too. This restatement of tort says in pertinent part, in the context of tortious interference, improper means are those that are independently wrongful, such as misrepresentation of fact or any other wrongful act recognized by the state statute or common law. We've taken the unfortunate position in our brief of having to say about Ms. Larkins that she encouraged her client to lie. And I'm done. I gotta go sit down.
We only have one argument on this side.
Yes, sir. Yes,
Okay.
yes, Your Honor.
Go right ahead.
Good afternoon, Your Honors. My name is Jared Davenport, and I have the pleasure of representing Miss Angela Larkins, a fellow member of the Tennessee Bar. This is a case about lawyers doing what lawyers do. We interpret the law, we advise our clients of their options, and we advocate on their behalf. Litigation privilege, I believe attorney-client privilege was mentioned earlier. I think you meant litigation privilege, is designed to allow just that, to allow attorneys to do their job without fear of civil liability or becoming co-defendants with their own client. My client's been a licensed attorney in the state for over 20 years. She's an experienced and respected family law attorney. This case is about Ms. Larkins' representation of her client in a divorce proceeding, her interpretation of the law, her legal advice to her client, and her advocacy on her client's behalf. Now, I'm happy to answer any policy questions that support our position in this case.
I'll start by asking one. So does the litigation privilege encompass the ability to make a misrepresentation of fact?
Under UNARCO, it does not. Or
Okay.
it would qualify for the litigation privilege, I want to be clear. So UNARCO lays out specific examples of what takes you outside of the bounds of the litigation privilege. It gives you specific examples. Those examples have a common theme. It's criminal conduct, it's fraud, trespass, threats, violence, and then there's a catch-all or other criminal conduct.
But it can include a non-criminal misrepresentation of a fact.
I believe that UNARCO is clear in saying that it's a criminal conduct that would remove the litigation privilege in the context of improper means.
I don't remember it putting the caveat in it that it had to be criminal.
And the basis for that argument, Your Honor, is it lists these criminal acts, and then it has a catch-all that says, or other criminal conduct, okay? So I think that that's clear, but even if there was an ambiguity, the canons of construction help us there. If there's a catch-all at the end of the list, the scope of that catch-all is limited to the nature of what comes before it. And so I think the UNARCO court would say that it's criminal conduct that would constitute improper means, and improper means would remove the protection of litigation privilege. Now, so we've already started the policy conversation, but of course we're here because there was a motion to dismiss that was granted in this matter. So let's look at the facts, and we can talk about the facts as they're alleged. I'll go through the litigation privilege, of course, and how plaintiff has not pled sufficient facts to remove the protection of the litigation privilege. Now, we've heard from the plaintiff through their brief and his attorney's oral argument. Without restating his position, essentially he says that he pled sufficient facts to remove the shield of litigation privilege from Ms. Larkins. We're limited to the four corners of the pleadings. The procedural posture requires us to accept proper factual allegations as true. The key is factual allegations, not legal argument, not legal conclusions. And the trial court did just that. And Chancellor Atherton granted the motion to dismiss based on the four corners of the amended complaint alone. The trial judge found that even if we accept those allegations that were made in the amended complaint, must fail as a matter of law. So in this context of litigation privilege, there's 4 elements. Only one of those is at issue on appeal. And it's really only one portion of that one element that's at issue in appeal. Plaintiff conceded the other elements of litigation privilege. That Ms. Larkins was acting in her capacity as counsel, the conduct was related to litigation subject matter, and that there was a real nexus between the conduct and the litigation.
Okay, I'm going to go back to my question because I knew I had read this somewhere and I wasn't hallucinating, at least not at the immediate moment. I think it's from the Zitzo versus Auto Owners case, maybe, which is from the Eastern District. But it says, in the context of tortious interference, improper means are those that are independently wrongful, such as threats, violence, trespass, defamation, misrepresentation of fact, restraint of trade, or any other wrongful act. So misrepresentation of fact, there's no requirement that it be a criminal type of act. That does qualify as improper means that would negate the litigation privilege, would it not?
At least in the federal trial court that decision was made. And now plaintiff has made an argument that we should take that broader approach. And I would say that that's broader than what UNARCO considered. So UNARCO, again, considered the criminal conduct. So if we look at, let's see, so it's page 17 of the appellant's brief, and this may have been where Your Honor saw this as well. So that first full paragraph on page 17 of the appellant's brief that starts in the context of tortious interference, and it goes on to mention threats, violence, trespass, defamation, misrepresentation of fact, restraint of trade, any other wrongful act recognized by statute or common law. That's not the law in Tennessee. That's not the law in Tennessee state courts. There is a citation to UNARCO that follows that sentence. But if you look at the UNARCO opinion on that page, it's a block quote from a Missouri state court. So UNARCO considered this issue as one of first impression. The prior case law was focused on statements, defamatory statements in the litigation context. UNARCO extended it to conduct, so conduct-based litigation privilege. In doing that, it considered some other jurisdictions and how they would approach it, including Missouri and Hawaii. It looked at those jurisdictions, and then it ultimately came down to the takeaway from UNARCO is in the context of improper means. And the takeaway is that it's fraud, trespass, threats, violence, or other criminal conduct. The UNARCO court was aware of this broader rule that was stated in Missouri, and then it was also mentioned in the Zitzow decision that you mentioned earlier. I mean, the Zitzow came after UNARCO, but the rule is the same. They were aware.
So your position is that under Tennessee law, the litigation privilege applies even if the attorney made a misrepresentation of fact?
As long as it was in good faith, yes, Your Honor. Because obviously there's multiple elements to litigation privilege. The improper means really isn't an element, it's an exception to the litigation privilege. So if you meet the elements of the litigation privilege, I would say that the misrepresentation, whether on purpose or not, would not remove the litigation privilege.
Okay.
So to close this loop, we have the UNARCO court that's presented with these broader rules, and they adopt a specific rule in UNARCO that limits improper means to criminal conduct. I'm not sure how more clear UNARCO could have been, because they considered the rule that plaintiff advocates here. And instead of adopting that rule, or saying we adopt the Missouri rule, or restating the Missouri rule, or saying that conduct other than criminal conduct would remove the litigation privilege, they just didn't do that.
And I keep coming back to the fact that taking the allegations in the complaint as true, which we must do and the trial court must do on a motion to dismiss. If Ashley had previously, under oath, said, I don't have any interest in this property, I don't know why my name's on this deed, but I don't own it and I don't own any property. And then the lawyer says the complete opposite, and says she may have an interest in this property. She may have a 1/3 interest, and that's valued at least $120,000. Do we sanction that? That's okay?
So my response would be, my client, Attorney Larkins, was approached by her client with a deed that had her name on it, and that's alleged in the complaint, so it's properly before this court. She's approached with her client with that deed in her hand well, not physically in her hand, but had her name on the deed. Attorney Larkins is a family law practitioner, knows about the injunction that's in place since there's an ongoing divorce proceeding. She knows that her name's on the deed, so she's looking at the facts, she's looking at the law, and she's saying, hold on a second. Let's make sure that we're not going awry from the injunction. And I also want to bring the court's attention to Lawrence, the plaintiff's son in this case, used a mechanism under that injunction to get his name off of that same deed. That at least suggests that somebody was concerned about this injunction, the same injunction that my client was concerned about. So all Ms. Larkins did was look at the facts objectively. She saw the deed, she spoke with her client, she advised her of her options, and then her client made a decision. And her decision was to not quit claim the property. Now, the mention of unless all the other divorce issues are handled, I think it's framed negatively in some of the briefing. But that's another one of the mechanisms under that same injunction statute to where you can get relief from the injunction statute, and then you can dispose of the property. So I think that and we've talked about the UNARCO case today. We've talked about it at length in the briefing, and there's a reason for that. It's because it's the case that extended this litigation privilege to conduct. So it's the landmark decision here that gives us guidance. Quickly, I do think that the facts are instructive here. So UNARCO's president entered into a confidentiality agreement when he retired. After he retired, one of UNARCO's competitors reached out to him and wanted to discuss some of their business dealings. The former president made UNARCO, or made the competitor and the competitor's attorney aware of this confidentiality provision, okay? And then the competitor's attorney then drafted an indemnity provision to help protect this person because he knew he was going to breach the agreement, this third-party agreement. Not only that, he played a pivotal role in eliciting testimony that would be in breach of the agreement. So then UNARCO sued the attorney and other parties, the competitor and some other folks. The trial court granted the attorney's dispositive motion, denied the others because there was an issue there with the others, but then denied or granted the motion as to the attorney specifically, which went up on appeal and was upheld. So then we get those four elements. So good faith and improper means those are the two key issues in our case today. And they gave us guidance there. So good faith under UNARCO at least suggests you have to view that as the whole sentence. So good faith is to act in good faith for the benefit of the client to get the privilege as an attorney and not in your own self-interest. So it's not at issue here that Attorney Larkins was not acting in her own self-interest. And it's in the complaint. I mean, it's alleged that it was a means to enhance her client's bargaining power, not Ms. Larkins' bargaining power for some reason. So it's our position that she was acting in good faith. The plaintiff's argument is pretty simple here. They're arguing that Attorney Larkins misrepresented the law and misrepresented the fact. So misrepresenting the law, that's a legal conclusion that's not entitled to deference. That's not a proper factual allegation. To get there, we would have to accept the legal conclusion or accept the legal argument of the plaintiff about what the law says and what it means. So that's not entitled to deference even given the procedural posture. The facts, the factual portion of that, they're just insufficient to support the claims when faced with the litigation privilege. Now, this doesn't affect the claims, obviously, against the non-lawyers that are the non-lawyer that's a defendant here. So, as I mentioned before, opposing counsel is arguing for this court to essentially ignore UNARCO and apply this rule from Missouri, or apply this rule from a federal trial court, neither of which are binding on this court, and just ignore UNARCO and accept a broader rule than what UNARCO clearly stated. So there's no allegation of criminal conduct in the complaint. So if we accept the rule that that litigation privilege, when we're talking about improper means to remove that protection, requires criminal conduct, then the complaint must fail. In the alternative, even if we're considering potential civil claims, which I don't think UNARCO considers that, but even if UNARCO did, it's still not sufficient to remove the privilege. She was just doing what lawyers do. I see my time has ended.
Mrs. Convalinka? Yes, sir.
First of all, the factual statements keep creeping into the arguments, into the brief that are not in the amended complaint, such as what Ms. Larkins was thinking at the time with respect to her client. We have that replete in this briefing we have in connection with this. Now, I will say to you that I have 317 Southwest 3rd, 227, specifically page 237, which is the case of UNARCO, Material Handling, Inc. It says in pertinent part that following the precedent, I'm skipping a lot, but following the precedent established by our Supreme Court in Simpson, so the Supreme Court's already acted with respect to this is not brand new, and by integrating the persuasive reasoning stated by the Supreme Court of Hawaii in Kahala and the Court of Appeals in Mackey, we have concluded that the litigation privilege in Tennessee applies to an attorney's conduct prior to the commencement of action if the attorney was acting in the capacity of counsel for a client or identifying a prospective client when the conduct occurred, et cetera, and he mentions all four. I'm skipping to the bottom where it says, in the context of conduct of an attorney that is alleged to constitute tortious interference with contractual rights of a client's adversary or potential adversary, the conduct shall not be privileged if the attorney employed wrongful means. Wrongful conduct with regard to a contract is not a crime. This jump in reasoning, I think, is based upon the last sentence. And the last sentence says, in this context, wrongful means includes, inter alia, fraud, trespass, threats, violence, or other criminal conduct. It does. And so they're picking up the term or other criminal conduct to say that it's confined to criminal conduct when we're up here in another sentence and saying it deals with contractual rights. I disagree that this is limited to criminal conduct in connection with this. And again, with regard to what the allegations in the complaint are or what the allegations in the complaint are, on pages 151 of 150 through about 157 of the record. And again, I will stand by those two paragraphs that I read to you before. It is clear that we're saying that Ms. Larkins knew. She actually knew that the law was incorrect. And that's when they say we were asking about a mistake in the law, it wasn't a mistake in the law. We take the position that Ms. Larkins knew that that wasn't the law and had her client, she on behalf of her client, she was writing this letter to gain some leverage or advantage in connection with this. If that's where we are in the state of Tennessee with respect to lawyers, you could go ahead and make representations to your client and to others to leverage. I don't think that's what's really intended. Thank you.
Thank you. Well, I want to thank the parties for your presentation. And you should receive our opinion